Hello friend, how are you? I am advocate Gaurav Kumar Gupta. I am chartered accountant and MBA finance and PhD holder. My project derivative market future trend analysis. आज जो हम सेक्शन 11 CPC के बारे में जिक्र कर रहे हैं, रेस जुडिकेटा के बारे में बता रहे हैं, सेक्शन 11 को डील कर रहे हैं। सेक्शन 11 हमें बताता है कि नो कोर्ट shall try any suit issue in which the matter directly and substantially in issue has been directly substantially in issue in a former suit between the same parties under whom they any of them claim litigating under the same title in a court competent to try such subsequent suit, the suit in which such issue has been substantially raised has been heard and finally decided by such court. फाइनली जो डिसाइड होता है जो कोर्ट द्वारा, इसका एक्सप्लेनेशन हम क्या करेंगे कि द एक्सप्रेशन फॉर्मर सूट शैल डिनोट ए suit which has been decided prior to the suit in questions whether not it was instituted prior thereto. पहले जो क्वेश्चंस डिनोटेड हुआ था, जो फॉर्मर सूट हुआ था, वो पहले ही प्रायर डिसाइड हुआ था, उसी के क्वेश्चंस को वो एराइज करता है। एक्सप्लेनेशन 2 करता है फॉर द पर्पस ऑफ दिस सेक्शन द competence of a court shall be determined irrespective of any provision as to right of appeal for the decision of such court. The matter above referred to must in the former suit have been alleged by one party and either denied or admitted expressly impliedly by the other. Any matter which might and ought to have been made ground of defense attack in such former suit shall be deemed to have been a matter directly or substantially in issue in such suit. Directly or substantially in issue in such suit. Any relief claim in the plaint which is not expressly granted by the decree shall for the purpose of these sections be deemed to have been refused. Where person litigate bona fide in respect of a public right or private right claimed in common for themselves and others, all persons interested in such right shall for the purpose of this section be deemed to claim under the person so litigating. The provision of this section shall apply to a proceeding for the execution of a decree, and reference in these sections to any suit issue former suit shall be construed as reference respectively to proceeding for the execution of the decree, questions arising in such proceeding, and for a former proceeding for the execution of the decree. An issue here and finally decided by a court of limited jurisdictions competent to decide such issue shall operate a res judicata in a subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try such subsequent suit, the suit in which such issue has been subsequently raised. सूट जो होगा सब्सिक्वेंटली रेज किया जाएगा, आगे बढ़ाया जाएगा सूट को. अदर देन ए सूट is too wide and may have the effect of extending the principle of res judicata to proceeding which are not judicial proceeding having regard to the amendment proposed by the committee. The two section 11 of the code have been regarded to difficulty which may arise is clause B of new section 11A is accepted. The committee decided to omit new section 11A. The committee were informed that the law commission had made certain recommendation with a view to ensuring that the principle of res judicata might apply to cases which were trivial by court of limited jurisdictions. After careful consideration of the matter, the committee are of the view that the decision of the court of limited jurisdictions should be so far as such decisions are within the competence of the court of limited jurisdictions operate a res judicata in a subsequent suit, although the court of limited jurisdictions may not be competent to try such subsequent suit. The suit in which such questions is subsequent raised. A new explanation to Section 11 code has been inserted accordingly. Res judicata applicability. Res judicata applicability कब होता है? Suit by landlord for recovery of possession is not bare by limitation, where application by tenant for fixations of a standard rent is dismissed on the ground of period of limitation. Where the defendant was not a party in a earlier suit, the plea of Benami was taken, which was not taken earlier, it was held that the same was not hit by the provision of res judicata. रेस जुडिका का प्रोविजन को द्वारा यह हिट नहीं किया जाता है. if the cause of action is not same in both the proceeding, it will not operate a res judicata. It will also not operate a res judicata when the law has since the earlier decision be altered by competent authority. Applicability of applicability of withdrawal of a special leave petition. Permission to withdraw a leave petition cannot be equated with an order of its dismissal. In the circumstances of the case, the High Court has not exercised a proper and sound discretion in dismissing the writ petition in limine on the sole ground that the applications for special leave on the same fact on ground has been withdrawn unconditionally. एप्लीकेशन ऑफ प्रिंसिपल ऑफ रेस जुडिकेटा. रेस जुडिकेटा का प्रिंसिपल का एप्लीकेशन क्या है? एक्स पार्टी डिग्री. इन द एप्लीकेशन फॉर अमेंडमेंट द प्रेयर was for inserting the words order 51 rule 1 civil procedure code in the memo of appeal. In this application there memo of appeal, this application there was no prayer to deficiency in court fee required for filing a regular appeal. Since there was no prayer in the aforesaid application for permitting respondent number 2 to pay the requisite court fee, the order passed on his amendment application would not bar him in moving an application for extension of time to deposit the required court fee for treating the appeal into a regular appeal. The prayers in both the application were in fact different so far as the subsequent application is concerned. To court is in exercise of its inherent power under section 149 Civil Procedure Code can permit as regard the extension of time for payment of the court fee. Civil Procedure Code alternate remedy. Mayor laches in filing the appeal and allowing the limitations bar, such filing the appeal cannot also be ground for invoking the jurisdictions under Article 226 of the Constitution. Application for evasion under Section 10(3) Clause C of Tamil Nadu Building Act 1960. Section 90 of the Act would not operate as bar to the maintainability of present suit for evasion filed by the respondent under Section 10(a)(3) A Clause 3 of the Act. Section 10 Clause 3 and Section 10(3) Clause 3C come into operation under different set of circumstances in order to justify an order for evasion under Section 10 Clause 3(a)(3) of the Act. The landlord must satisfy the rent control that any member of his family is not occupying for purpose of the business which he any member of his family is carrying on a um, carrying on a non-residential building in the city, town and village concerned, and that therefore he, the member of his family, needs the said building bona fide for the said business. The said business, when an application for evisions of a tenant under Section 10 3 clause C is rejected on the ground that he is not his occupation of portion of the building for the business which is carrying on, and therefore he is not entitled to evict the tenant who is possession for a non-residential purpose. The fact cannot prevent the landlord from maintaining any application under Section 10(3)(a) Clause 3 of the Act for eviction of the tenant on the ground that he, any member of his family, is not occupying for the purpose of a business which he, any member of his family, is carrying on non-residential building which is his own. Any decision given by the rent control and application under Section 10(3)(c) cannot therefore operate as bar under Section 92 and application revision filed under Section 10(3)(a) Clause 3 of the Act. Similarly, when once of the appellate authority had come to conclusion that the application for revisions of revision petitioner was not maintainable under Section 10(3)(c) of the Act, in as much as the respondent not carrying on any business in any portion of the building, the appellate authority was equal, not competent to go into questions where the respondent needed the premises means क्या हो गया building for the purpose of the business which is was the carrying on. Therefore court was of the view that the present petition for eviction filed under Section 10(3) of the Act is not barred by Section 90 of the Act by the principle of res judicata enacted in the section. Eviction suit में finding of court in earlier evisions petition that suit belong to government estate, but the retired employee not being an unauthorized occupant would not operate as res judicata in subsequent suit. Applicability of decree का applicability principle of embodied in the section apply to all litigations including writ petition, though the section is restricted to civil suits. Applicability between parties के बीच applicability क्या होता है? Parties it is well settled that for a ex parte decree to operate as res judicata between the parties, it is to establish that the defendant in the suit were served, which was decided against them. The doctrine of res judicata will the apply. Ex parte decree will operate a res judicata of a party in spite of conjunction है, इसके बावजूद, in spite of का होता है के बावजूद, service of notice on him did not put in this his appearance to contest the suit appeal as the case may be. एप्लीकेशन बाय लैंडलॉर्ड द्वारा जब एप्लीकेशन टेस्ट ऑफ होता है, द टेस्ट इज वेदर द सेकेंड प्रोसीडिंग इन्वॉल्व ए न्यू कॉज ऑफ एक्शंस, वेदर इट इज मेयरली एन अटेम्प्ट टू reiterate the same fact to get a judgment in his favor on the same old cause of action. It is quite clear that a court can, upon fresh evidence, alter vary the judgment previously made if the cause of actions of the subsequent proceeding is different than what was his former. But of course, if there is no evidence of any fresh circumstances, the second applications may be barred by principle of res judicata. A trivial, insignificant change will not oust the applicability of the principle of res judicata. Each case will have to be decided on its own fact for finding out as to whether the change is of nature which alter the position of the party. If the answer in affirmative, the principle of res judicata would not be applicable. Reference was made by the counsel for the petitioner to Rule 18 of the rules frame under the Act, which was submitted on its basis that as legislature did not want to principle of res judicata to apply to an application under Section 21, the only restrictions imposed is that within an year of the dismissal of the previous application, the second one cannot be moved. This is not the proposed and object Rule 18 or no doubt restricts landlord for moving the second application within a year of dismissal of the first, but it does not rule out F9. The applicability, the applicability of the principle of res judicata, the principle of behind the res judicata is different than one which led the legislature to frame Rule 18. The two things should not be mixed up and confused. An application under Section 21 of UP Urban Buildings Regulation of Letting Rent of Evisions Act 1972 on same ground within the specified period. In the present case, an application under Section 21 was made by the landlord, but that was independently of the permission secured under Section 3 of the old Act, and moreover, the suit of evisions on basis of the permissions was also filed, which now constitute the subject matter of the second appeal. The bar of res judicata against the landlord may not therefore be said to arise. Matter to be heard and finally decided. Finally decided या matter को सुनना. What is necessary for the applicability of Section 11 Civil Procedure Code is that the matter should be have been here and finally decided. The bar of res judicata does not depend on the ability of a right of appeal. There was no right of appeal against the order passed by the Privy Council. There is no such right against the order passed by the Supreme Court. It cannot be said that the order passed by the Privy Council, the Supreme Court would not operate res judicata as there is no right of appeal. Res judicata principle of Res judicata principle applicability of Section 11 Civil Procedure Code apply to suit, but the principle of underlying the bar of res judicata would be applicable if it is proved that a particular issue has been previously decided by competent court in a proceeding between the same parties. In the earlier suit filed by B against A, B sought a declaration of his right to manage the property. Graveyard and Dharag. The court held that his property was Wakaf property. The graveyard Dharag house was used as a Musafir Khana in subsequent suit by a Mutwali against B for position. The decision in earlier suit would operate res judicata. In an earlier suit by the appellants for a declaration that they were owners of the property none a bada takia. It was held that the property was Wakaf property. The decisions was confirmed by the Supreme Court as subsequent suit by the defendant for the declarations that the appellants had no right over the property permissible to reopen for the same issue as the principle of res judicata apply. When the dispute determined by the court is earlier decisions, the objections, petitions, all consequent proceeding hit by principle of res judicata is not maintainable. If the same plea is allowed to be taken up in the subsequent suit, if that is accepted, that will bring to inconsistent device which will create an anomalous situations. To avoid that, explanation 6 was added. Basis of रेस जुडिकेटा. रेस जुडिकेटा का सिद्धांत बेसिक क्या होता है? रेस जुडिकेटा इज नॉट टेक्निकल रूल. इज ए रेस जुडिकेटा इज नॉट ए टेक्निकल रूल. इट इज रूल ऑफ पब्लिक पॉलिसी. एप्लीकेशन ऑफ प्रिंसिपल ऑफ बार ऑफ रेस जुडिकेटा. रेस जुडिकेटा का बार का सिद्धांत क्या एप्लीकेशन होता है? When once an application of plaintiff move in the very court on the same ground on which the suit is founded has been rejected, the plaintiff must be held to be bear by res judicata principle, analogous thereto for raising the same plea again by means of a suit. It is settled law that where the questions raised in the suit has already been decided adversely to the plaintiff in an application either under order 9 under 9 under order 9 the rule 13 of the rule 30, otherwise the same questions cannot be reopened in a civil suit on the principle of the bar of the res judicata, where the judgment was obtained by fraud. It was held that the principle of res judicata does not apply in such case as where no conflict of interest was noticed between the defendant, nor was it necessary to decide the validity. Kept in the earlier suit, the judgment therein was held not operate as res judicata. Principle of res judicata when not applied. A suit by party for his acquired right during pendency, earlier suit is maintainable and therefore not applicable. Principle of res judicata cannot apply the proceeding for attachment before judgment. Normally, when an issue is decided in the suit, in the appeal over the suit, it cannot be agitated in the subsequent proceeding. Counsel for the respondent has argued that the principle will not apply to case where the issue is decided against a party through the decree normally is in favor. Decree normally is in favor. Bar of res judicata. Bar of bar of res judicata not applicable in subsequent stage of suit, where order for personal appearance of party was passed under order 10 rule 4 in earlier stage of proceeding, held that such order did not finally adjudicate the right of parties. As such order was introductory in nature, court could not be precluded in passing different order 10, rule 4, clause 1, in subsequent stage of proceeding. Therefore, bar of res judicata was not applicable. Applicability of res judicata. When issue raised in petition have already been agitated earlier, the Union of India and its officers are bound to follow the same even if the members of the firm's majority of the engineers were not individually parties. In the case before the Allahabad High Court, since the issue now raised have been agitated twice over, it is not permissible for the petition to once again regitate the matter by coming now under the clock of forms. Assistant settlement officers ordered the guaranteeing Rutuari Patta, appeal not filed, effect of the finally attached where under section 46 would cover not only the determination of nature of the land but also the determination of the person entitled to ruaitory patta in respect of the land. These two matter being questions to be determined for the purpose of the act and are matter filing within the decision of assistant settlement officer, the appellate tribunal under section 11. They shall also binding on the parties person claiming under the in a suit proceeding in a civil court under section 43. Pre-exemption proceeding. Pre-exemption proceeding का मतलब हुआ where in a pre-exemption proceeding finding was made that subsequent sale of land was same transaction and no appeal by purchaser under subsequent transactions was made finding did not operate a res judicata in subsequent writ petition. In a case where the tenant choose the deny the title of landlord did not raise the plea of section 106 of the Land Reform Act, role of might and out envisaged under explanation 4 in section 11. CPC squarely apply to such case. No res judicata on principle of might and out. Where writ petition challenging validity of notice for revision given by government and title of government to land in questions was disputed by the petitioner. High Court gave liberty to government to establish its title in competent civil court held that the fact that AP Land Grabbing Prohibitions Act had comes into force before the disposal of writ petition by High Court under which a special court was formed was not brought to notice of High Court. Civil suit filed by government under Section 8 Act statutory right was created in favor of a state under the Act to judict a public mischief. It cannot be preclude for having the preclude having the recourse to the provision of the Act by operation of the principle of might and out in explanation for section 11 CPC when it title interest had not been finally determined by the High Court. Pure questions of law. Decision of pure questions of law does not operate a res judicata if cause of action in former and subsequent proceeding is different. Moreover, it will not operate a res judicata when law has changed. Land Acquisition Act 1894 applicability of a, a reading of section 54 of Land Acquisition Act would indicate that the appeal shall lie in any proceeding under the Act only to High Court against the award and decree of a reference court. Further appeal to Supreme Court would be under section 136 of the Constitution, read with section 11 of CPC. Earlier judgment rendered not inter parties in similar case cannot be res judicata while subsequently determining the market value of similar land. Bihar Land Reform Act 30 of 1950 Section 4G and 4H Principle of Constructive Res Judicata. Now it is well settled that the principle of res judicata extend to revenue matter and writ proceeding also in the background. It has to be seen whether an impugned order can be assailed on the ground the previous proceeding were under section 4 H of the Act and the impugned order was for a proceeding under section 4G of the Act. Though in the counter affidavit it is stated that the previous proceeding were the section 4G of the Act. In view of the fact that the matter has been agitated and decided between the parties and the state government never move against those order, it become final and now it is not open the state government to start a fresh proceeding. It will hit by the principle of constructive res judicata. Claim regarding exclusive right in plots. The consolidation officer and the appellant authority gave judgment for the present petitioners. Father and revisional court has negative the claim of his aggrieved by the judgment of the revisional court. The present petitioners father approached the High Court under Article 2026 of the Constitution. During the pendency of the writ petition, the present petitioners have been substituted as their father died. Held on fact, the revisional court has committed an error in holding that the petitioner's claim stood bare on the principle of res judicata, as his claim was not recognized in the suit filed by the petitioner father as the earlier occasions. As regards the petitioner's claim of exclusive tenancy in some of the plots, the counsel for the petitioner has not been able to satisfy about the petitioner's claim in any specific plot. It is also doubtful whether each petitioner had ever raised any exclusive right in any of the dispute plot. In such circumstances, the High Court was not prepared on the entertain the petitioner's claim regarding exclusive right in some of the plots at this stage. Principle of res judicata include the principle of constructive res judicata are applicable to proceeding of writ petition. It now it now well settled that a proceeding under Article 2026 of the Constitution it is a civil proceeding. The principle of res judicata, including the constructive res judicata, are applicable to such proceeding. These ground might and ought to have been raised by those who previously filed their writ petition, they are precluded from raising the same in constructive res judicata scope of the questions whether the appellant's position has become the adverse since the death of the mother of the respondent, that the appellant could be said to have prescribed title as Mersuder of land in his possession on basis could not have been raised in the earlier suit for partition by the appellant. The point cannot be said to be constructive res judicata by reason of the decision against appellant title in the earlier suit. It would be impermissible to permit any party to raise on issue inter se where such an issue under the very act has been decided in earlier proceeding. Even in res judicata, in its strict sense, may not apply, but its principle would be applicable. Parties who are disputing if they were parties in any early proceeding under the very act raise the same issue would be stopped from raising such an issue both in principle of estoppel and constructive res judicata. Principle of constructive res judicata can be involve even inter se respondent. Competency of court. Expression. The competency of the court comprises territorial pecuniary jurisdictions in inherent lack of jurisdictions in like nature. The court is not robbed of its competency even it is decided that a particular suit is not maintainable under the provision of any act or otherwise. Compromise. A compromise, however, stand in the eye of law independently of any order of court passed thereon, although a compromise decree has no greater validity than compromise on which it is founded. It even though the decree may be nullity for want of jurisdictions, the compromise may none the less survive. Thus irrespective whether any order was passed not by the High Court on the basis of the compromise would still remain in that writ petition the opposite party had claimed to be exclusive tenure holder. Thus, the position of the opposite party was altered on his disadvantage. It is thereof not open to the petitioner to turn round now say that the compromise would not bind him. He stopped for doing so. When an order become final in term of compromise, same matter reopened suo moto in without jurisdictions. Constructive res judicata applicability of wherein a earlier revenue proceeding the defendant had taken the plea that he was not tenant on the suit land. In the subsequent suit by purchaser for permanent injunction, it was not open for the defendant by constructive res judicata to take up the contention that he was cultivating the land as a permanent tenant. Conclusive finding of second appeal disposed by a common judgment. Second appeal against the decree ensued for possession on the basis of tenancy right as well as other second appeal against the decree in suit for declaration of title along with possession in respect of the same party and same subject matter. Both appeals were heard and decided together by common judgment. Third appeal filed only against the title suit held that the final and conclusive finding of the second appeal decided by common judgment in the suit for possession bar the third appeal in one suit on the principle of res judicata. Res judicata writ petition dismissed in limits with one word's order rejected effect of. However, from the order dismissing the special leave petition in limits in cannot be inferred that all the matter agitated in the said writ petition were either explicitly implicitly decided. The technical rules of res judicata, although a wholesome rule based upon public policy, cannot be stretched too far to bar the trial identical issue in a separate proceeding merely on the uncertain assumption that the issue must have been decided. It is not safe to extend the principle of res judicata to such extent so as find of merge guesswork. Therefore, one word order would not constitute the bar, certainly not at the stage in which the case was at the maintainability of suit. Res judicata would not apply if the court holds that it has no jurisdictions of unanimous interpretation of law. High Court had admittedly exclusive jurisdictions, was competent to entertain the writ petition under Article 26 of the Constitution. A pure question of law as to whether the matter in dispute between the parties was cognizable by the civil court, the consolidation authorities came up for considerations before the High Court in the aforesaid writ petition. Upon the decision of these pure questions of law, one way the other did not depend the jurisdictions of the High Court to entertain the to entertain the writ petition aforesaid. It was open to respondent 3 and 4 to challenge the correctness of the decision of High Court in aforesaid writ petition in an appeal before the Supreme Court. They, however, those choose not to do so and allowed the said decisions to become final. On the other hand, what they did, what was that is the revisional filed against the order of settlement officer consolidation the asserted before the deputy director of consolidations and apparently in the teeth of the decision of this court in the aforesaid writ petition that the matter was not cognizable by consolidation authority. Their assertions was accepted by the deputy director of consolidation on conceptual of the authority. Hereinafter mentioned High Court answer to this question is in the negative. Court competency in decided former suit. The present respondent, the present respondent number 1 and 2 5 went up in appeal before the first appellate court, first appellate court, who upheld on the finding of the trial court. The appellants, the appellants in this case thereafter prefer an appeal in High Court, and the judgment and decree passed by the two court below were affirmed in second appeal number 609 and 952, which was disposed of 25th April 1957. In the instant appeal, the issue was whether the decisions in the former suit courts operate res judicata on the trial court. In the former suit not having the necessary jurisdictions, the whole proceeding none is held at. In the pertinent to note here that having lost in the trial court in earlier suit, respondent number 1 to 5 file an appeal in the first appellate court, putting the same valuation and never raised by any objections with regard the pecuniary jurisdictions of the trial court. The same act was repeated again in the court where, having faced with the adverse decree, they came up in second appeal. Having lost in all these proceedings, it is now not permissible for respondent number 1 to 5 argue that judgment and decree duly passed by court below the earlier title suit, where the nullity and should be treated non ist in the law for purpose of invoking the principle of res judicata. Decision of rent control of jurisdictions of fact does not operate a res judicata. Decree of ejection against two joint tenant. Discretion of relief order pass earlier petition same set of fact. It has been repeatedly held that proceeding under section article 2026 of the Constitution of India are discretionary, and that a petitioner who does not approach the court with clean hands is guilty of suppression and the misrepresentations of material fact, attempt to fudge forfeits. Forfeits means जब्त कर लेना every claim for the grant of discretionary relief. In this instant case, court is clearly of the opinion that the petitioner is indulged in chancery and guilty of apart instant petition. In second petition is subsequently the same fact. Second petition on the same fact surely bear by the principle of res judicata. Decision in former suit within the section 11 explanation. The decision of the district court was given in appeal arising out of the suit which the institute subsequently stood finally decide before the High Court disposed of the second appeal. The decision was therefore on in a former suit within the meaning of section 11 explanation on civil procedure code. Earlier decision holding that decree was nullity not operated res judicata. The executing court had refused to exercise jurisdiction and to execute decree on the ground the decree was a nullity. The Bombay Rent Hotel Lodging House Rent Control Act 2020 of 1947 had no application to the building in cantonment areas. The defect having been removed at decree obtained the basis the Bombay Rent apply. Critical cantonment are having validity amendment act 1970. It cannot be said that the earlier decisions holding that the decree nullity operated res judicata. अगले वीडियो में हम आपको बताएंगे अर्लियर पिटिशन बिफोर हाई कोर्ट क्लेमिंग सेम रिलीफ अंडर ऑपरेटर रेस जुडिकेटा अर्लियर रीट डिसाइड ऑन मेरिट सब्सिक्वेंट रीट एडिशनल रिलीफ साउट ऑन कॉज ऑफ एक्शन सेक्शन 40 ऑफ एविडेंस एक्ट 1872 रेफरेंस टू रेस जुडिकेटा के संबंध में सेक्शन 40 एविडेंस एक्ट 1872 कैसे डील करता है थोड़ा सा पार्ट्स को बता देते हैं सेक्शन 40 ऑफ द एविडेंस एक्ट विदाउट यूजिंग द टर्म रेस जुडिकेटा रेफर टू द कॉन्सिक्वेंस ऑफ रेस जुडिकेटा इज बिकॉज ऑफ सेक्शन 40 दैट द जजमेंट which is relied on by a party in subsequent suit in support of its plea of res judicata become relevant can be read in evidence held that a party to a decree a proper person claiming through such party can under section 44 of the evidence act be allowed to avoid the effect of the decree on ground of fraud or collusions and assert that the said decree cannot be relied on for the purpose contemplated by section 40 thereof which is include providing the basics for the plea of res judicata in view of the inclusion of section 14 section 44 of the said act. However, since section 43 is not included in section 44 of the said act, conclusive decree will still be relevant to support the plea of estoppel if the ingredient of estoppel are made out. अगले वीडियो में हम आप सूट फॉर डैमेज ऑफ ब्रीच ऑफ कॉन्ट्रैक्ट कंस्ट्रक्टिव रेस जुडिकेटा बार ऑफ रिटन स्टेटमेंट बाय कंस्ट्रक्टिव रेस जुडिकेटा के बारे में डिस्कस करेंगे. आज का वीडियो यहीं पे वाइप आउट कर रहे हैं. डेट्स ऑल.